Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about dower rights and what that even is. From laws against selling donuts on Sundays to ordinances that prohibit tying a giraffe to a telephone pole, the annals of American jurisprudence are filled with archaic laws, while still technically on the books, are rarely, if ever, enforced. For example, in Alabama, it's illegal to wear a fake mustache in church if it causes laughter. Massachusetts forbids dueling with water pistols. And in Oklahoma, tripping a horse is a misdemeanor. However, not all outlawed, outdated laws are mere trivia or historical oddity. Unlike these whimsical holdovers by a bygone era, dower rights, a centuries-old protection for surviving spouses, usually the wife, are actively enforced in Arkansas, Kentucky, and Ohio, and can impact estate planning in those states. Dower rights can also resurface in some states where they're no longer on the books if a spouse died prior to the law's abolishment. Although dower rights in other state laws can provide a surviving spouse with a safety net, they are not a substitute for intentional estate planning. Spouses are well advised to go beyond minimum legal requirements to incorporate more modern and robust legal protections for each other. Historically, dower rights, a legal concept dating back to English common law, gave widows the right to one-third of their husband's estate for their lifetime, providing them support at a time when women could not own property. Similar rights, known as courtesy rights, entitled a widower to his deceased wife's property for the widower's lifetime, but only if they had children together. Now, in a few states where they persist today, dower and courtesy rights grant a surviving spouse an automatic interest in real estate owned by the decedent spouse, whether or not the surviving spouse is omitted from legal documents. So exactly how do dower rights work? Dower rights grant the surviving spouse an ownership interest as a life estate in the deceased spouse's real property. A life estate means that the surviving spouse can use and enjoy the property during their lifetime, but they cannot sell it outright. Upon the surviving spouse's death, ownership of that portion of the property typically passes to the next of kin or the deceased spouse's named beneficiaries. Dower rights also terminate when spouses divorce. In some states, spouses may sign a release, forfeiting their dower rights. Dower rights supersede a last will and testament, meaning that the surviving spouse retains the dower interest, even if they are left out of their spouse's will or their spouse dies intestate, meaning without a will. These rights apply to real estate, regardless of whether the surviving spouse is named on the property's title. Dower and courtesy have mostly been abolished or replaced by more modern statutes, but they remain on the books in Arkansas, Ohio, and Kentucky. In Arkansas, a spouse's share depends on having children. The surviving spouse gets a one-half life estate in the deceased's real property if the deceased spouse had a child or children, or one-half outright, not a life estate, if the deceased spouse had no children. This right takes precedence over creditors' claims in probate. In Ohio, a surviving spouse gets a life estate in one-third of the deceased spouse's real property that they own during the marriage. The right, which ends only by death, divorce, or written release at each property transfer, allows them to also receive one-third of rents or profits from the property for life. And in Kentucky, when a spouse dies owning property in their sole name, the surviving spouse inherits half of that property outright. The surviving spouse can also receive a life estate and one-third of any real estate the deceased spouse owned during the marriage, but not at the time of death. Let's talk about how dower rights can affect an estate plan. Dower rights can complicate estate planning and must be taken into consideration in the 3 states that I just mentioned. They may still apply in other states if the spouse died prior to the abolishment of dower right laws. In these instances, because the surviving spouse has a legal claim to a portion of the deceased spouse's property, the deceased spouse cannot just leave the entire property to someone else in their estate plan. As a result, dower rights can complicate plans to sell or transfer property, it may potentially conflict with the deceased's wishes, especially if the deceased wanted their children or others to inherit outright. If someone wants to leave their entire property to their children from a previous marriage, dower rights could give their current spouse an ownership stake or life interest in some of that property, leading to conflicts between the estate plan's beneficiaries and the surviving spouse. For example, a person in a second marriage who owns a home solely in their name may wish to leave the home to children from their first marriage. However, if they reside in Kentucky, their current spouse may have a life estate in one half of the home. This means that the surviving spouse can live in it or rent it out and collect rent from one half of the property's value for the rest of their life. The children from the first marriage still inherit the house as the will directs, but their ownership is subject to the current spouse's one-half life estate. They do not get full control until the current spouse dies. A surviving spouse's dower rights in Arkansas, Ohio, and Kentucky are difficult, but not impossible to terminate. Kentucky considers an act of adultery and subsequent abandonment grounds for canceling a spouse's dower rights. In some cases, prenuptial or postnuptial agreements may also be used to waive or modify dower rights. As societal norms have shifted and legal frameworks have evolved to reflect a more equal view of spouses in a marriage, dower and courtesy rights have largely been co-signed to the dustbin of history. In 2017, Michigan was the last state to repeal dower rights, following the U.S. Supreme Court's 2015 decision in Abergefell versus Hodges, which mandates states to recognize same-sex marriages. By eliminating dower, Michigan modernized its inheritance and marital property laws to treat spouses equally, regardless of gender. However, the spirit of dower and courtesy rights as the safety nets of their time, protecting surviving spouses from possible destitution and dependency, living on in a modern legal concept known as the elective share. An elective share is a legal provision that permits a surviving spouse to claim a minimum share of accounts and property from their deceased spouse's estate, regardless of the deceased spouse's estate plan. Like dower rights, the intention of the elective share to prevent a survivor from being disinherited and left destitute, and gives them some level of guaranteed financial security. Also known as special share or forced share in some jurisdictions, the specifics of the elective share vary by state, but generally it gives the surviving spouse the option, hence the term elective, to either accept what is left to them in their deceased spouse's estate plan, or instead take a legally defined percentage of the deceased spouse's assets, usually between 1/3 and 1/2, depending on the state. Now, most states have an elective share law. California is a notable exception, but it and other states have laws, including community property laws, homestead exemptions, and spousal and family allowances that protect surviving spouses in a similar manner. While dower rights and more modern protections, such as elective share and community property laws, offer a fallback for surviving spouses, they should not be exclusively relied on. Every marriage and every family has unique dynamics. Relying on default provisions and automatic protections may not adequately address a surviving spouse's specific needs or your unique goals and objectives. Married couples can incorporate additional protections for their spouses into their estate plan, such as life insurance, beneficiary designations on retirement accounts, and a trust that provides income for a surviving spouse while preserving property for other loved ones. Owning property jointly with rights of survivorship can also provide for a surviving spouse by passing property to them directly outside of probate. In some cases, a prenuptial or postnuptial agreement can help clarify financial rights and responsibilities, especially in second marriages or when one spouse has significantly more assets than the other. A strong estate plan goes well beyond the minimum legal requirements a state may offer and is tailored to a family's unique situation and changing circumstances. Spouses should work together with an estate planning attorney to create a custom plan that respects state law, each other, and their personal shared concerns. I want to thank you all for watching. Please like and subscribe our page below to keep up to date on estate planning, how it works, and how it may benefit your family. Thank you for watching. I'm Kelly Longtin.